Hi.
Hi. Okay. Good. People are joining us. This is good news. So we've got some time before we start. It's going to be exciting. Talk about contracts. Jerry, you can hear me, right? Okay, good.
No, you're good.
Okay. So, because I'm doing this without a net, because I'm doing it at home and Lindsay is nowhere around. So as long as my kids don't stomp on the floor, we'll be okay. There we go. Okay.
That's five. Let me see.
Well, it's 5 total. It's you, me, and 3 others.
Oh, got it.
So, because we have Sonia and Rebecca, and I don't know, Falhija at Gmail. Who is that? Because that's not a name I'm familiar with. It's okay if you want to turn your camera on and say hi.
Okay,
Fatma.
now I know who it is.
Well, I was going to say, I don't know if I've met you, Fatma. Hello.
No, you haven't.
Oh, well, that explains it.
Yep.
So sorry, we're just going to give it a few more minutes to see who else joins since we said we would start at 6. So we'll give
Hi,
it a few more-
Jerry. Hi, John.
Hello. Was that Sonia?
Hi. I cannot really see you because my screen doesn't have the camera.
Oh, okay. Well,
No.
at least you can hear me.
¿Quién me la manda? ¿Usted? Huh?
I said, at least you can hear me if you can't see me.
Yeah, I can hear you. Thank you.
Hi, Rocio. Hi, Karen. Oh, Karen's connecting. So we'll give it a few more minutes for everybody to log on. Okay.
Hello, hello. Anybody hear me?
Hello, Nicholas?
That would be Alfredo. Sorry.
Oh,
I'm
Alfredo.
using my kid's laptop. Sorry, guys.
Gotcha. Oh, yeah, the last name she gave me away. I was like, oh, gee, I wonder if I know that person.
Yeah. Trying to use the headphones. They don't work, so. Yeah. Okay. We're good. Are we still waiting a few more people?
Yeah, well, it just turned 6 o'clock, so I was gonna
Sure.
give it a minute. Oh, look at that. People are just popping up. Welcome, welcome, everybody. See, this is an on-time crowd. They wait for 6 o'clock and like, we're ready to go. Okay.
Hello.
Hi,
Hey,
Juan.
Hello, Juan.
I'm on time, I guess.
Well, so we thought we'd try something new with the Zoom. I thought I'd try doing this series of Zooms at 6 o'clock. So that way, for those people that are dual agents that have, other things happening during the day that we can try to catch some folks at night. So we're going to see how this works.
Okay, that's fine. Yeah. Just so the topic, and I really want to hear what you have.
Well, so the idea behind this series for February, March, and April is, the contract changes from time to time, and it's probably not a bad idea, as we're starting to look into the busy season to just sort of refresh our recollection about what's going on, even though a lot of you are, you're very busy agents and using the contract all the time. There's still stuff that comes up or stuff that gets missed. So this is really kind of designed to just, take a look back and, other than the spots that you fill in, to really talk about what's in the contract. Because whenever folks come to me to say, hey, I've got a problem, the first place I go is the contract to go
Exactly.
take a look at what we're doing. And so tonight, what we're going to talk about is, I was thinking about how I was going to structure this. So tonight, we're going to talk about the Maryland Realtors contract. And I think we're really only going to have time for the first 11 pages. So we're not going to talk about addenda tonight.
Mhm.
We're just going to talk about sort of that base first 11 pages of contract. There's a lot of stuff in there. And then next time, I may talk about some other stuff, but I'm going to focus there. And then I think next time we meet, I'm going to talk about the GCARR contract. And for that, that's going to be the first 7 pages. And then the third time we meet, we may talk about some select addenda as well as maybe some differences to compare and contrast with the GCARR contract. But I think maybe it's better to focus on Maryland Realtors tonight. We'll do GCARR next month, and then we'll do a comparison thereafter, or maybe we'll start our comparison next time. Because there are some differences, and especially if you work in Montgomery County or you're doing stuff in DC, you're going to want to know what's happening with the GCARR contract, because GCARR is the one that's used in DC as well as Montgomery County.
Yep, great idea. Yep, good information.
Okay. So it is 6:03, so we're going to get going. So I'm going to share my screen with you all. And we are going to talk about the Maryland Residential Contract of Sale. Okay, there we go. So if I've done this right, you can look at what I'm looking at. And this is page 1 of the residential sales contract. So the first thing we see is that this contract is legally binding. If it is not understood, seek competent legal advice. So one thing that I will hit home, and I think this is especially important for seasoned agents. You are not a lawyer. You may play one on TV. However, sometimes even when you know the answer to a question, because you're seasoned, you've been out, you've seen it all, or sometimes you say, I've seen it all, and then there was that one deal. Just remember, you are in fact not a lawyer. And so if there is something going on in this contract that requires interpretation, you really need to direct your client to an attorney. And so when it says, if you don't understand this contract, seek competent legal advice, that's what it means. But it is very easy for a realtor to fall into the trap of providing legal advice when they don't mean to, especially when you, especially, this is a document that you're dealing with day in and day out, and you know it very well. Just as a general reminder, you are not an attorney, so don't provide legal advice. Okay. So this form is designed and intended for the sale and purchase of single-family residential property located in Maryland. That's true. Don't use it in DC, okay? You can use it in Montgomery County, and although I'm not talking too much about GCARR, I will say this. If you choose to use the Maryland Realtors contract in Montgomery County, make sure you use the Montgomery County jurisdictional addendum with it that GCARR has, okay? Because if you don't, you are going to miss a lot of local ordinances. But the other thing that I'm going to say about this in terms of local ordinances, and also just as a general reminder, I've said it before and I will say it again. Remember where you are practicing. There are addenda for Frederick County. There is addenda for Prince George's County. I've seen the Southern Maryland Association of Realtors, SMAR. There's addenda for, down south if you're, in Charles or St. Mary's County. So pay attention to where you are, because there could be jurisdictional specific addenda that you need. Now, other than Montgomery County, which I will get into with GCARR, I'm just going to tell you that, the Maryland Realtors contract is fine, but you have to remember where you're practicing so that you pull the appropriate addenda for the county in which you are, okay? So that's that. So the next thing we come to is time is of the essence. The reason why time is of the essence, that's a legal term, okay? Time is of the essence. And what it means is that, there's deadlines in the contract. We have to adhere to the deadlines. I realize a lot of lenders think it's a mere suggestion. However, there are deadlines. And if you're not paying attention to your deadlines and, getting extensions when necessary, you can find yourself out of contract very, very quickly. And if you are out of contract and no one wants to extend to sort of fix that problem, someone's going to be in breach, and you want to make sure it's not your client, okay? So time is of the essence. And so what they're telling you is that you need to perform in accordance with the timelines that you're setting up in the contract. So make sure you're hitting those deadlines. And if for some reason you're not able to, make sure that you are in communication with the realtor on the other side, and make sure that you are getting your addenda together to extend time when necessary. Okay. So paragraph 1, date of the offer. I don't think I need to say too much about that. You put on the date that you're writing the offer. Paragraph 2, the seller. So I'm going to tell you, because I've seen enough contracts with this on it. The seller is never owner of record of the property. Okay, I've never met a seller whose actual name is owner record of property. You should know who you are buying from if you are the buyer. If you are the listing agent, and I would certainly understand this, there are times when names are murky. In fact, I just was working on a file today where through a series of deed changes, there was a mistake in vesting. And so there was a husband and wife, and the husband has passed away. And guess what? Ordinarily, we would think that title would just vest in the wife and we're going to move on. But in this case, because of a series of deed changes, the vesting was actually not correct. And so they were not listed as husband and wife on the deed. Therefore, we have to go with the legal default of tenants in common. So now the wife and the estate of the husband are selling the property. That one was a little bit tricky, so we're going to have an addendum done. But if you are writing contracts for your buyer and your seller is owner of the property, that's wrong, because owner of the record owner of the property is not a seller. Okay, a seller is a person. A seller is an entity. Okay, so make sure you know who you're purchasing from if you are a buyer. And if you're a listing agent and a buyer hands you an offer, correct them. Maybe the seller doesn't have the correct thing. Maybe you as the listing agent have not properly listed the property with the proper name. Okay. And I do want to take a minute to know who your client is, much more on the seller side. As we all know, dead people sell a lot of real estate. Okay. Make sure that, and entities, LLCs, what have you, investors. One of the things that I look for in title is signature authority. So if you are dealing with an estate, make sure you've looked at the letters of administration. So that way, you know, the person that you're dealing with is authorized to sign your, in this case, we're talking about the contract, but just as an aside, make sure that person is authorized to sign your listing agreement or your buyer broker agreement. Well, estates don't typically buy property, but either way, if it's an LLC, make sure that you're dealing with the person who has correct signature authority. You should be asking those questions. And those of you that work with me, you know, I ask that question a lot because we have to know who is signing what and who has the authority. So that's the seller name. So make sure that you are filling in the correct seller. There's a lot of ways to find that information. If you think it's not correct in the MLS, you can look at ESTAT. You can go into Maryland Land Records, and you can, you know, look at the actual deed to see how the property is vested. You know, if someone has passed away, then maybe it's an estate, maybe, and we do get it where, you know, husband and wife held title and one of the spouses has passed away, you know, so we just want to make sure that we know who our actual seller is. So paragraph 3 is the buyer. So one thing that I am seeing quite a bit of is one person will be the buyer. And then someone comes to me and says, oh, I want to add, the spouse is going to be on title, but not the loan. That's fine. As long as you and your lender are cool with it, we're fine. But here's the thing. Anyone who's going to be on title has to be disclosed to the lender, because the deed of trust, which as you know is the mortgage, has to contain the names of all people on title, because the deed of trust is the mortgage, it's the lien that goes on the property. And in order for it to go on the property correctly, it must have all the names of the people on title. So I'm going to tell you that your best practice here, oftentimes I'll say, well, just add an addendum that says so-and-so is going to be on title. The truthful answer to all of this is that whoever is going to be on title should be in your contract. So if you have a husband and wife that are going to be purchasing property, but only say the wife is going to be on the mortgage, or only the husband's going to be on the mortgage, or the cousin or whomever, everyone is a buyer. okay? And so everyone should be a party to the contract. So that's the buyer. Paragraph 4, property. So here, the property, we're just looking for the address typically. So make sure that you are putting in the address. So I think that one's okay. Number 5, the estate. So this is important because I've seen some folks get tripped up here. So in Maryland, we typically see fee simple property or property subject to ground rent. So as a reminder, fee simple means that you own the land and the buildings on top of the land, okay? All of, if you think about your bundle of rights, all of the rights in that bundle of rights are rolled up into the fee simple. You have it all. But we do have some properties that are leasehold. And in that case, you are purchasing the building, but not the land on which the building sits. So if you are doing work in Anne Arundel County, Baltimore City, Baltimore County, those are the main, the top 3. Baltimore City is like the number 1, if I think about it, where I see ground rent. Okay. But here's the part that's important. If you're a listing agent and you've listed your property, make sure that you've listed the property correctly as leasehold. If you are the buyer's agent, make sure that when you fill this out, either as fee simple or as subject to ground rent, make sure you do it correctly. And listing agents, when you receive the contract from the buyer, make sure you pay particular attention to this paragraph. Because I have seen where a buyer's agent puts in that the property being conveyed is fee simple, and yet there's some ground rent. And that's okay, because if everybody agrees that the conveyance is going to be fee simple, guess what has to happen? Well, since the seller says they're conveying a fee simple, the seller has to redeem the ground rent. And maybe the seller wasn't planning on spending a few $1,000s to do that. I mean, I'll admit, in the grand scheme of a real estate contract, redeeming ground rent is not always that much of an expense. But as the seller, if that's an expense you were not planning on paying, make sure that if your property is subject to annual ground rent, that you make sure the proper item is checked off here. Okay? Because otherwise you could be subjecting your seller under the law to redeem that ground rent for the buyer. So make sure that you are selecting the proper estate, especially if you're in one of those hot counties like Anne Arundel, Baltimore City, or Baltimore County, where we do see quite a bit of it. Okay. So I see someone's in the chat. I'm going to check the chat in a little bit. But if you do have questions as we go, you can put your questions in the chat, and then I'll sort of round back to the chat to answer questions. Okay. So purchase price. That one I haven't seen too many problems with. People are pretty good about putting down the price they're willing to pay. Payment terms. Make sure that you are filling this out completely. Okay. I think that one of the downsides, make sure that, your deposit, so here's the one thing I want to say. So either the buyer has delivered or will deliver within X number of days of contract, the EMD. And whatever number of days you put in there, if it's 3, 5, 2, whatever that number is, make sure that EMD is getting submitted within that amount of time. Or guess what? Time is of the essence. You've breached the contract. Okay. If there's any additional deposits, which is B, make sure, all of that is being done. And then I want to talk about C. All deposits will be held in escrow by blank. Make sure you put in, make sure that you are clear as to who is going to hold the escrow. I see a lot of contracts where that is blank. Okay, so hopefully you'll be putting Realty Title Services in there. But Fairfax, I know, also holds escrows. Or sometimes maybe the listing agent wants to hold, whatever the case may be, especially if it's a HUD property, there are some issues. But make sure you're clear about who is holding the escrow, okay? And if Realty Title Services or someone who is not a real estate broker is holding the escrow, make sure that you also execute a written escrow deposit agreement, okay? That's that escrow deposit agreement. Many of you come to us and say, hey, go ahead and sign this. And I say, great, as soon as I see that money, I will sign it, okay? Or Jaminia or whomever is around will do it for you with Realty Title, okay? So I will also tell you in general, because it states here that the purchase price is going to be paid in cash, wired funds, bank check, etc. And then I don't really know why. Well, I guess I do know. So they ask you to place the deposit in either an interest-bearing account or a non-interest-bearing account. So here's what I'm going to tell you. I can tell you for a fact that the Realty Title Services escrow account is non-interest bearing. So just make sure that you select non-interest bearing when you do that. There are very few reasons why a earnest money deposit would be in an interest bearing account. Because, and Jerry, since you're here, you can tell me, I am pretty sure that the Fairfax escrow account is also non-interest bearing. So,
Correct.
so as a result, if Realty Title Services, and this is even like a general issue, Realty Title Services, really any title company, and I think I can make a broad enough statement that almost any brokerage, no one has a non-interest bearing account. No one has an interest bearing account, rather. So although the contract gives you a choice, I'm just going to tell you select non-interest bearing, because for the people that are generally going to be holding this money, no interest is going to accrue. Okay. And then you have paragraph 8, the date of settlement. Okay. So put in your date of settlement. And just remember, this is the date. This is, and it also says, or sooner if agreed in writing by the parties. Okay. So that's the date, unless you all agree to do it sooner. And that's fine. But this also goes back to that time is of the essence issue that we were just discussing. Settlement date, out of all the dates that are in this contract, that's kind of the biggie, because lenders will hold up your loans if you're out of contract. So you do need to make sure that you have those extensions done if you are blowing past the date that is written in paragraph 8 for your settlement date. I'm just going to take a little look at the chat here for a second. So Shirley Connors, hi Shirley. So good question about ground rent redemption. So just to talk about ground rent redemption for a minute, to go back to that item. So it can be easy or it can be hard. If the ground rent is registered, we can typically find that out using public sources. So if the ground rent is registered, it's really just an issue of the title company will contact the holder of the ground rent, get a payoff, just like, a mortgage or a homeowners association account, and they will provide the redemption amount. The redemption amounts, there's a statutory scheme based on when the ground rent was created, how much it is, this and that. And what will happen is, as part of settlement, when we redeem as part of settlement, we will draft a ground rent redemption deed, as well as include the payment amounts that are needed. And once settlement has occurred, we send a check to the ground rent holder along with the deed. They cash the check, they sign the deed, send it back to us, we record it, and that's the end of it. Ground rent is redeemed. If the ground rent is unregistered and you don't know who the leaseholder is, that's when things start getting a little more fun. There is a way to do it. There is an office that handles it. There's posting involved, and it's a much longer process that requires some more attention to detail, but it can be done. So if that were the case, that that was the situation, we could talk about it as to what would need to be done in that particular case. And in that case, most likely, you'd want to take care of it after settlement because of the time involved. So that is redemption of ground rent.
Hey, John, if I may add just one quick note before we go
Sure.
for any further. For the settlement date, as you mentioned, it is correct. It is certainly something we have seen. I know Jerry and I and Anna have seen it, and I'm pretty sure you have as well. And you are correct. I mean, we do need a date there, but I mean, some of the things that I do see the agents do, and listen, at the end of the day, I know they're being creative, and we were all just trying to get these contracts in sooner than later and hoping nobody else wins the offer. But I've seen some really weird things, and I'm just going to mention it to you because I know some of the agents out there listening to us right now possibly have seen this or use it themselves. I've seen TBD, to be determined. I've seen 25 days after data ratification, yet there's no data ratification mentioned whatsoever. Or I'll even see end of March. And at the end of the day, there isn't something specific there. And it is very crucial. And you did mention it earlier, that a specific date must be identified. And we all learned this in contract. And when we first took real estate classes, you must, in order for a contract to be valid legally, you must have a beginning and an end date. And in this case, a settlement date is certainly what is needed here in order for having what is known as the meeting of the minds. So just wanted to point that out.
Yes, and I would tell you that the settlement date is a material, is one of the most material items in your contract, along with the price of consideration. So you really do have to have it. And if you say end of March, just put March 31st. That's the end. Okay, so thank you. All right, so let's move into paragraph 9, financing. So a lot of contracts do have financing. Now, the way that the Maryland Realtors contract handles this is actually kind of interesting, because they have this financing paragraph here, and it's, you know, buyer's obligation to purchase is contingent upon the buyer obtaining a written commitment for financing a loan as follows. So they're setting up the contingency here. So it says we're making this contingent on conventional financing, FHA, VA, whatever the case may be. Or you're going to select no financing right over, I assume you can see, well, maybe you can't because I can't highlight it. Or you're, you know, doing no financing, okay? And that's fine. Or maybe there's owner financing, whatever the case may be. And then it goes on to describe how this contingency works. Okay, because buyer within whatever number of days of contract acceptance is going to go and put in their loan application after contract acceptance. And then seller at seller's election can, upon written notice to buyer, declare the contract null and void if the commitment is not obtained by the buyer within X number of days. Okay, because you see that first line at the bottom of page 1, it says buyer agrees to make the written application within X number of days. And then it goes on to say, if a written financing commitment is not obtained by the buyer within X number of days, that's when we start talking about how we're going to get out of this contract. Okay, so the first one is if you don't have it within X number of days, again, this goes back to time is of the essence. So if you find that your lender is being slow on things, make sure you're talking with your listing agent, okay? Because you're going to want to need to maybe, you're going to need to extend this contingency perhaps. So seller, if you don't hit this mark, seller at seller's election can declare the contract null and void of no further legal effect. Or the buyer, upon written notice to the seller, which must include evidence from the lender of the buyer's inability to obtain financing as provided in paragraph 9 of this contract. Okay, So basically paragraph 9 sets up your contingency, and then paragraph 10 continues about how this is going to work, okay? So either buyer or seller can declare the contract null and void based on these situations. But that's not the end of the story. Although I'm not going to talk about the addenda tonight, remember, there is also your conventional financing addendum that sets up more information. There's the FHA financing addendum, the VA financing addendum, okay? And so if your contract is running into trouble for financing, the first place we start the analysis is with paragraph 9. Did you make the contract contingent on financing? Okay. Did you hit these timelines? Where are you? Okay. So so basically what happens here is, in either case, regardless if it's the seller or buyer, the deposit shall be dispersed in accordance with the deposit paragraph of the contract. Okay. And the deposit paragraph of the contract, if you remember, is 7. Okay, that's paragraph 7. So we're gonna disperse in accordance with that. And if the buyer has complied with all of the buyer's obligations under the contract, including those with respect to applying for financing and seeking to obtain financing, the release of the deposit needs to go back to the buyer. So what that means is, if the buyer has done everything they're supposed to do and they are not getting financing through no fault of their own, the deposit can be returned to the buyer. But let's say the buyer didn't obtain the commitment within the required timeline. Guess what? The seller can declare the contract void, and the deposit may not go back to the buyer because the buyer failed to obtain something that they were responsible for. Okay, so you want to make sure, again, that you're paying attention to your timelines to protect your client and their money. All right. Now, we've all been around this block enough times to know that sometimes one loan program doesn't work out, and so we need to re-up and try a different loan program. So paragraph 11 talks about alternate financing. So here's the situation, folks. A buyer can change the financing if they want to, okay? That does not necessarily change the character of the financing addendum. However, if you were doing conventional and switching to FHA, you really do need addendum, because there is that special FHA addendum with special FHA language, okay? But the basic issue here is, as long as you do everything on time and you stay on time and you're within your time frames, it is the buyer's choice what financing they're going to do, as long as they accept it. And if the buyer does choose to accept alternate financing other than the financing previously described in paragraphs 9 and 10, that's okay, because it will be deemed to be acceptable to remove the contingency. Okay. So, but the real key to alternate financing is, you can't mess up your timelines. If you have to go into alternate financing and for whatever reason you can't get that commitment within the time frame that you've initially set out, you need to amend your contract, send in an addendum to extend that time frame. Because oftentimes we talk about, oh, the settlement date's passed, we need to, kick out that settlement, extend the contract. But just remember, there are other dates within your contract that may also need extension. Okay, so the settlement date, of course, is the big one, but when you are dealing with financing and the fact that you are to deliver certain items to the seller on time, make sure that you're also paying attention to moving those dates out. And so just maybe if you're having to move one date, it probably means your settlement date needs to be moved out too. So you can always do one addendum for the price of 2 items. Okay, so if you're having issues with your financing, you're going to want to address all of that at once. So next, paragraph 12. Oh, let's see, someone has a question. Yes, so Sonia says, is no financing similar to a cash deal? That's exactly what a cash deal is. There's no financing. The other way that that happens, and you want to be careful, this is going to hit your investor clients. Some people say that there's no financing contingency because they're dealing with a hard money lender. Or someone's feeling lucky and says, I'm pretty sure I'm going to get a mortgage. I'm not going to condition my offer on getting a mortgage. Okay. So here's the deal. So no financing means no financing. It can mean cash. And the reality is, if for whatever reason, what your client was planning to do in the background, maybe they were going to get a hard money loan, maybe they were going to get funds from a family member, however they were planning to deal with this purchase. If you don't do it or it doesn't work out and ultimately your seller comes up short or your buyer comes up short, guess who's going to be in breach of contract? It's going to be your buyer because they said they could buy this house and suddenly they can't. So what I'm going to tell you as a listing agent is if there is no financing contingency, you're going to maybe want to make some inquiries of your buyer to say, hey, buyer, there's no financing contingency. Let's see the money. How are we doing this? Okay. So no financing doesn't necessarily mean that it's cash, but a lot of the time it can be cash. Okay. So let's move on to the home and environmental inspections. Paragraph 12. So the buyer acknowledges, subject to seller acceptance, that the buyer is afforded the opportunity at buyer's sole cost and expense to condition buyer's purchase of the property upon a home inspection and environmental inspection. If the buyer desires a home inspection and/or environmental inspection, such contingency must be included in an addendum to the contract. The buyer and seller acknowledge that the broker's agents, subagents are not responsible for the existence or discovery of property defects. Okay. And so if you're going to do an inspection, you need to initial the appropriate spot, whether you are declining or you are attaching an addendum. Okay. That one's fairly self-explanatory. If you're going to do an inspection, take care of your addendum. And then we get to paragraph 13, which is inclusions and exclusions. This is important because you need to know what is included in the sale. Is that refrigerator included? Is the alarm system included? TV, wall mounts. But one thing that I don't think has made it to the list yet is solar panels. Okay. And so I do see contracts where there's an additional inclusion for solar panels as a fixture of the property. So I'm going to take a minute here because I want to talk about solar panels. Solar panels, when they are on the property, they are either leased or someone bought them outright. Solar panels are the bane of the title company. So if you have leased solar panels, part of the deal here is that the lease can be transferred from the seller to the buyer. We recently had a situation where solar panels were written in as an additional inclusion right here. And it said additional inclusions, it said solar panels convey. Okay, great. But guess what? The solar panels were leased. So what do you do? And it turned out that although the solar panels conveyed, the buyer decided that he didn't want to assume the lease. Well, now what's our problem? The listing agent said, well, of course the buyer knew that the solar panels were there. Of course, we said they conveyed. They've got to take the lease. Well, guess what, folks? When you include solar panels here as an additional inclusion, that means they go with the house. And that makes sense that the seller is not pulling them off the house as an exclusion. Okay, they're attached to the roof, they're there. If the solar panels are leased, that is a separate issue. Okay, so if it is your intention, sellers, that your buyer take over the lease for the solar panels, you should condition the sale of your property that the buyer must assume the lease on the solar panels. Okay, because don't forget, in order to transfer lease solar panels, the buyer has to qualify with the solar panel company to do that. Okay. Or you could end up with a situation like we had in the title company where the solar panels, where the buyer decided he didn't want the solar panels. He didn't tell his agent. He didn't tell the title company. He didn't tell the seller. The only person he told was the solar company, and the solar company didn't tell anybody either. So nobody knew. So as a result, we had this issue of what to do about these solar panels because there was a lot of people not talking. And the fact is, the contract was silent about an obligation to the contract was silent about an obligation to assume the solar panel lease. So buyers and sellers, you are going to want to make an inquiry as to if you see solar panels, are they leased? Are they owned outright? Okay. And sellers, if they are leased, you are going to want to both put in as an additional inclusion here that the solar panels convey, but also, and I'm going to jump ahead for just a second because you could put it here, but a more appropriate spot would be back here on page 4, where it says any other addenda and special conditions right here. That's an excellent spot to say buyer must assume solar panel lease as condition of sale or something to that effect, because you want to make sure that you lock that buyer in, because you don't want a situation where you're telling people that the solar panels convey, but if you don't own the solar panels, you want to make sure that you get your sellers out of that. You want to make sure that your sellers are not stuck with that lease. Okay. So remember, the panels and the lease for the panels are two separate items that need to be dealt with. Okay. So going back to our inclusions and exclusions. But that's the big thing that I do want to talk about, because a lot more homes do have solar panels now. And I don't want your clients to find themselves, I don't want your clients to find themselves on the losing end of the stick with a solar panel lease. So make sure, if you are the listing agent, that you are appropriately making the buyer responsible to assume that lease. And on the buyer side, make sure you understand that, there's going to be an obligation to these solar panels. Okay, if that's the condition of the contract. Okay, but I do think that the rest of the inclusions and exclusions are fairly self-explanatory. Obviously, if there are, exclusions, this is a good one. I'll just sort of talk about chandeliers. If you have an antique family heirloom chandelier that you have no intention of conveying with the property, make sure that you are very clear that your antique heirloom chandelier that's attached to the ceiling that otherwise would convey, make sure that you have properly excluded it. Okay. Anything attached to the walls goes with the house. Okay. Because those are fixtures once it's attached to the house. Maybe there's some additional personal property. Maybe there's some couch in the basement nobody wants to move. Throw that in as an inclusion and move on. Okay. So make sure that you are specific as to what you want. And buyers, I'm going to tell you this. So years ago, I was involved in a transaction on a lakefront property, and there was a dock. And I knew some history, some personal history about this particular property and about the dock in particular. And so in that particular contract, we made sure as an additional inclusion that the dock was included, because I had a feeling there'd be some problem from the neighbor who had actually built the dock. And wouldn't you know it, good thing we stuck that into the contract, because once you know, the neighbor came up and said, I want to be compensated for my dock. And all we had to say was, well, guess what? The dock is on our property. Your seller said that it was included. So if you have a problem, you need to go talk to the seller about it. Okay. So sometimes if there's something you're not sure about, you want to make sure that it gets included. Make sure as a buyer, you stick that in. Okay. Okay. Paragraph 14. Agriculturally assessed property. The agricultural use assessment is a reduced property tax assessment. To be eligible, the land must be actively used for agricultural purposes. The agricultural transfer tax is imposed under section 13301 of the tax property article. And if the property is assessed in agricultural use, the buyer does not intend to use the property for agricultural purposes, the tax may become due and it could be substantial. I personally would change that could to will, because the agricultural tax is no joke, folks. If you are working on a property that is agricultural, and we do see a handful of them each year, maybe, you're buying someone's family farm, what have you, and maybe you're not planning to farm anymore. Maybe you want to do a small subdivision. Maybe you're just someone who likes a lot of land, but you're not going to farm it, period. You are going to get hit with this tax. This is not a tax that we as the title company can just tell you about, because it's a little nuanced. The issue with agricultural property is we have to actually get the tax numbers from the county. And there's a little bit of interplay between the county and the state in order to get the tax numbers. But this is where you start hearing about $30,000, $40,000 transfer tax bills. Under the statute, and what it says here, under the statute, the seller has to notify the buyer in writing that the transfer may be subject to the tax, and that the buyer is responsible for the tax unless you negotiate a different agreement. Now, I'm going to tell you, if you're not sure, if things are unclear, you can always look up the property in SSTAT, and SSTAT will tell you if it's an agricultural property. Okay, you don't necessarily have to rely on the representations of your seller. It would be helpful if you could, but sometimes people don't know, don't realize. I had one that was partially agricultural because it was zoned wrong. That was a whole other issue. But what I'm going to say here is, if you're buying if you want to, and the presumption in law in Maryland is that if you're buying agricultural property, the presumption is that it's going to come out of agricultural use. And so if you want to keep it as an agricultural property, there's an application that you have to fill out. So Realty Title can help you with the application. We'll get it. We'll send it off to the appropriate taxing authorities. But I will tell you, both the state and the applicable county have to sign off on it before it can be approved. And there's a 3-year look back period. The state and county will go and check on you or maybe it's a 5-year look back period. I forget exactly what, but they're going to come back and they're going to make sure that you are using the property the way you said you would, or else they're going to come back and collect that agricultural tax from you. So it's no joke, and it's very expensive. We had one recently where the parties had agreed that they were going to split it, and that's what they did. But you just have to understand that the tax it's a special tax that's assessed. It's not something it's not something that we can generate with our software. We actually have to go to the county and get them to calculate it based on the sales price. So let's check the chat. Let's see. Okay, so let's see. So Sonia is asking about solar panels. Solar panels should be in the listing seller's disclosure. Well, you're right. Solar panels should be in the listing seller's disclosure, but things get missed, and sometimes the character as to whether or not solar panels are leased or not. And it's fine if it's in the disclosure, but the disclosure is putting you on notice. What the disclosure is not doing is obligating the buyer to take on the lease. Okay, so just because you know the lease is there doesn't obligate the buyer to take on the lease. And what you as this listing agent wants to do is you want to make sure that the buyer is responsible for taking over the lease to get your seller out of it. Okay. And then Sonia also asked about this whole other, and she says she usually selects other when there's a cash deal. Yes, that's totally fine. Okay. So moving on. So forest conservation, I don't think we need to spend a lot of time on. Just know that there are taxes assessed and that it could be paid by. I actually have not seen that one come up very often. But then we have paragraph 16, which is lead-based paint. So lead-based paint is a big deal. We talk a lot about it in principles and practices. There is a whole entire form for it. So what I'm going to tell you is that you agents can also be subject to fines if this is not done correctly. And just remember that the disclosures and everything that's needed apply to properties that were constructed prior to 1978. Otherwise, you are then exempt. So pay attention to how old your house is, and pay attention to your obligations. And the second part of that is this paragraph B, which talks about renovation, repair, and painting of the property. Because a property is presumed under 1978 that it may have lead-based paint. If you're doing work there, you need to make sure, if you're painting or what have you, you have to make sure that whatever painting work is done complies with the renovation, repair, and painting that the rule that was adopted by the EPA in 2010. So what that means is that if a seller is engaging a contractor to repair or paint the property, they have to be certified by the EPA if that work is going to disturb more than 6 square feet of paint, or more than 20 square feet of paint for an exterior project. Okay. So a seller who personally performs covered work is required to be certified by the EPA. Okay. There is an exemption if it's the seller's principal residence. But the seller has the ultimate responsibility for safety. So just make sure that you understand that. Paragraph C is lead poisoning prevention. So there is a form for that. This really deals more with leased property, leased residential property. You need to, there are certain forms that need to be dealt with. There's a link there to the form. And it has to do with property that is now, has been, or will be a rental property in the future. So if you are selling or purchasing a property that has been, will be, was a rental, make sure you're taking a look at this form. That's what they're getting at there. But then we come to paragraph 17. So this is the notice regarding disclosure of deferred water and sewer assessments. These are also called the front foot benefit. Okay. There's also typically disclosures elsewhere with the listing agent, what have you. But here's the deal. Okay. The seller, so According to the annotated code of Maryland, the contract for resale of residential property that is served by public water, which has a deferred water and sewer charge that was established by a recorded covenant or declaration, shall contain a notice disclosing that information about deferred water sewer charges. If the seller fails to comply prior to settlement, the buyer is entitled to rescind the sales contract without penalty or liability on rescission. The buyer is entitled to a full return of all deposits. If any deposits are held in trust by a licensed real estate broker, the return deposit to a buyer under this law shall comply with the procedures under section 17505. And the buyer's right of rescission shall terminate 5 days after the seller provides written notice in accordance with this requirement. So that's what happens before. If you go to settlement, the seller shall be liable to the buyer for the full amount of any fee or assessment not disclosed, unless the seller was never charged to defray the costs of public water or wastewater facilities. So what that means is, if the seller never disclosed it, the seller is now responsible for the full amount of any fee or assessment not disclosed. So if there's still, say, 20 years left on your front foot benefit and the seller didn't disclose that there was a front foot benefit at all, the seller is now on the hook to pay off the front foot benefit, is essentially what that means. So listing agents, you want to make sure that you have disclosed this correctly. Okay? Because otherwise it can be very, very expensive for your clients. In addition, there's a lot of different companies. US Utility is the one that I'm thinking of the most, that manage these particular front foot benefits. So when you're asking about front foot benefits, you may want to say, hey, do you get like an annual water bill from a place like US Utility or something? Because what I find is that a lot of people don't really know that they're paying a front foot benefit. They just know that some random bill for, $400, $600, $800 shows up once a year around December, and they've just kind of been paying it. Or occasionally they're not paying it. And then when it comes to title and we start asking questions and, well, gee, I don't know, and this and that. So listing agents, help your title friends out. Make these inquiries ahead of time so that way you're prepared and everyone is prepared with all of the correct information. And also, you may want to find out if your client is up to date on their things. But a lot of people I do find they're like, oh, you mean that $400? That's what that's for? Oh yeah, it's this. And like suddenly we get it. So just kind of ask that question. But like I said, failure to disclose the front foot benefit can be very expensive. Because either the contract can fail if they find out about it, or it's going to put the seller on the hook. Okay. Paragraph 18. Addenda or disclosures. So we've talked about those. Make sure that you are including the appropriate disclosures. Okay. And for those of you that are dealing with out-of-state sellers or non-resident sellers, one of the questions that you're always going to hear me ask, and I don't know that I've ever actually seen this addendum, but if we have a Maryland non-resident seller, just remember there is a withholding tax that needs to be dealt with. Okay. Someone who is a non-resident of Maryland is someone that maybe they have an investment property here, maybe they own a condo down in Ocean City or what have you, but they live in Pennsylvania or Delaware, wherever they happen to be. Or it's someone who did live here and then they moved, and it was their principal residence. And if it was their principal residence for 2 of the last 5 years under IRS rules, we can exempt them. Otherwise, we have to do Maryland withholding. The other one that gets caught here on Maryland withholding are members of the military. If you are working with members of the military as a seller, the one thing that I do want to talk to you about is members of the military are allowed to choose their domicile. Okay, so they can have a house here in Maryland and still be a non-resident because they can still be a resident of Florida or Washington State or whatever the case may be. because of how the military does things. If that's the case, we have to engage in non-resident withholding. However, there are certain exemptions that can be applied for prior to sale. So if this is something that you're facing, contact title first, because we can tell you how to mitigate or deal with this, okay? Unfortunately, it's true military members can be exempt from non-resident withholding, but it's not something the title company can provide. You have to apply to the state, okay? There's a form that needs to be submitted 21 days prior. So some of these addenda are really good for you because it can tip you off to issues that you're going to find when you come see me in title. All right. So just make sure that, you know, you go through this list, because you can also use this as a checklist to figure out if there's information you should be giving title in addition to disclosing. So let's see. Oh my goodness, it's 7 o'clock. Where did the time go? So let's see. So wood destroying insects, you know, I think that what we'll do is, I thought we'd get further than we did. I think Alfredo was right. He's like, I could talk about this contract for days on end. And I thought I'd get through this whole 11 pages in an hour. So that's okay, because we have our series of contracts. So I think that what I'm going to do is we're going to hold it at wood destroying insects. Basically, this is where we're going to talk about getting your termite inspection, and the buyer can deal with this at the buyer's expense. But there also is language in here about when it's a VA loan and then it needs to be a seller's expense. There's certain things going back and forth. But the other thing that's in here is, we'll go back to our time is of the essence. You see that there is an out here if there's a termite inspection that doesn't go well, okay? Because now we're talking about if repairs exceed 2% of the purchase price, the contract remains in force, but maybe it doesn't. You got 5 days, this and that. So what I'm going to tell you is that if you are dealing with a termite inspection and this is what your issue is, you're going to want to come back to this paragraph 19 and start figuring out what your remedies are, because maybe there's termites and maybe your client is like, I am not buying a house with termites. I don't care. I don't care how much remediation there is. I'm out. Maybe they can, maybe they're not, depending on whatever this paragraph is. So you're going to want to take a close look at that. So we will pick it up next time at paragraph 20 on the deposit, okay? And we will continue our discussion of the Maryland Realtors contract that way. Now, let's see if I can figure out how to, here we go. So in the chat, Sonia was asking, let's see, here we go. So Juan asked, do you advise to include a solar panel lease between the company and the seller along with the disclosures? So I don't think you need to include the lease in your disclosures, because what will happen when you're dealing with the solar panels, you should disclose that they're leased. And as a listing agent, like I said, you're going to want to make sure that whoever is buying your property is obligated to take over the lease. So what you may want to do, and this is really a buyer beware situation, right? You know, if your buyer asks to see the lease, you can, but I don't know if the lease would be different between the seller and the buyer, because essentially what happens is the buyer will apply to the leasing company, to the solar panel company, and they will be provided the terms of lease there. And I don't know, you know, especially if maybe you've had solar panels for 10 years and it's a 20-year lease, they may have updated the terms, what have you. And so it could be a helpful tool, but I don't know that you really have to provide your lease, the seller's lease, because the terms may have changed a little bit from that time. But the other thing you could do is you could contact the solar panel leasing company and say, hey, solar panel leasing company, do you have sort of a pro forma lease that, we can provide to people so they know what the lease is all about? That might, that's certainly helpful, but I don't think it's necessary. What you do have to do is just say they are leased. And like I said, I think it's just very helpful for your client as a seller to make sure that the buyer will take over the lease. And then Sonia asked, what happens if a listing agent neglects disclosure of a deferred water and sewer assessment? Well, Sonia, for that question, would point you right on back to paragraph 17. The buyer is entitled to rescind the sales contract. So for example, if a seller does not disclose the front foot benefit or the deferred water, and as the title company, we say, hey, there's a front foot benefit. That's not the seller doing it, that's the title company. And so once the buyer finds out about it, they have 5 days to decide whether or not they want to deal with the front foot benefit. So if they want to cancel the contract over the front foot benefit, they can. So as a listing agent, I'm going to tell you, make sure you disclose, because not disclosing can threaten your deal. So that is what I'm going to say about that. Does anyone else have any questions about I'm going to stop sharing now. Let's see. Does anyone else have any questions about what we've been talking about? No? Jerry, Alfredo, do you guys want to add anything?
Good job, John. Looking forward to the next time.
Okay. So, and also if folks don't mind telling me offline if you like having, because this is actually one of the most better attended items we've done from what I can see. So just let me know if, doing some things towards the evening like this is helpful to you. Because, we want to make sure that, as your partners in real estate, that we're here when you need us and that we can offer things at a variety of times for a variety of schedules.
John, can you hear me? This is Karen.
Hi, Karen.
Hi, this was awesome. I really enjoyed it. So if you decide to do more in the evenings, I would love to participate.
Okay. Well, so this series on contracts, which we may end up extending depending how far we get, because we're doing second Wednesdays. So the next one will be second Wednesday in April. I forget exactly what the date is. Alfredo, do you have the date on it?
It's also the 9th. Actually, it's the 9th also, yes.
Okay. It also happens to be April 9th or March 9th rather. So, so we will pick back up on paragraph 20, which is the deposit. Invite your friends. And, we will, we'll do this again next month.
Thank you.
Thank you, John. A lot of good information there. Thank you.
All right. Thanks, everyone. Have a good evening.
You too.
Thank you so much.
Thank you, you
Bye.
too. Take care.
Okay.